Good morning. Are you Federico Ortiz?
Yes, ma'am.
And will your client waive the formal reading of the motion and the indictment?
He will, Your Honor.
Mr. Ortiz, in cause number 25, DCCR 0589, you're charged with the state jail felony offense of abandoning or endangering a child, and that's from December 1st of 2024. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In that case, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Ortiz is not competent?
No, Your Honor.
All right, sir. In that case, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea.
Buckle up, guys. Today we're going to witness a tense courtroom opener. In this clip, the defendant calmly acknowledges the charge of abandoning or endangering a child and affirms a guilty plea. The exchange is clinical but heavy. Legal language masks raw consequence as counsel confirms understanding of immigration and appeal waivers. It's a stark reminder how quickly rights and futures are altered in a few formal lines.
Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, in cause number, let me find it, 24, DCCR 2334, I have a motion to revoke your unadjudicated probation.
The judge delivers the verdict and the sentence, 12 months in state jail, transforming the previous plea into immediate consequence. This short arc captures the court's authority, and the moment legal theory becomes lived reality. The defendant receives credit for time served, and the cadence of the judge's delivery underscores procedural finality. There's no drama, just irrevocable judicial closure. This moment forces viewers to reckon with how quickly a plea becomes a life-altering punishment.
Shows that you were placed on probation April 10th of 2025 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the months of May and June of 2025, and then also July of 2025. Is that true or not true? And then count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
True.
Then count 3 alleges that you failed to provide verification of completing the theft prevention class as ordered. Is that true or not true?
True.
And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I also have here on the tablet, in this case, some documents that have your signature on them that the state's marked as Exhibit Number 1. Did you also go over this with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes.
State tenders number 1?
No objection.
It's admitted.
Now the tone shifts to probation revocation. The court methodically reads alleged violations, and the defendant answers each count. The repetition of true echoes and compounds tension. These aren't abstract charges, but specific admissions that stitch together a narrative of failure to comply. Each admission tightens the judge's hands and foreshadows harder penalties. Watch how routine questioning builds cumulative jeopardy, turning scattered infractions into a persuasive case for revocation.
Mr. Ortiz, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of burglary of a habitation. sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm handing you the trial court certifications that shows that there are agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
The court finds sufficient evidence and pronounces guilt on burglary, issuing a 3-year institutional sentence. The sequence shows sentencing mechanics, credits, admonishments, and firearm ineligibility, painting the administrative machinery that follows conviction. It's a sober, procedural moment that also signals a personal turning point for the defendant. The clip makes clear how formal pronouncements translate into long-term restrictions and loss of liberty.
Good luck to you, sir. You can go back with the bailiff.
Thank you. Thank you, Your Honor.
Thank you.
And thank you, Mr. Rojas. Wow.
Randolph Vines, Mr. Rojas. Mr. Rojas is getting a gold star this morning.
It's been a while since I had one of those.
Rusty star.
Luke deserves to have that. But most of these cases are yours.
True.
Oh, well, y'all might have to share a star, huh?
That's right.
I don't require.
I'll take the whole thing.
It's always nice to get a gold star.
Do I still have it? No.
The courtroom breathes for a beat as the judge and counsel trade lighter banter, gold stars, and small jokes, providing a rare humanizing pause amid heavy proceedings. These moments matter. They relieve tension, reveal personalities, and remind viewers that the legal system is run by fallible people who use small humor to steady the day. It's levity, but not a distraction from consequence. This pause gives the audience a moment to process the seriousness that preceded it.
Good morning. Are you Randolph Vines?
Yes, ma'am.
And will your client waive a formal reading of the indictment?
He will, Your Honor.
Mr. Vines, in cause number 25 DCCR 1154, the state has elected to proceed on count 1 only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. and now I forgot where I was, but, illegal charges
If you have any
against you.
questions
If you
about
have any
the
questions
prosecutor.
about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
Randolph Vines enters and pleads guilty to unlawful carrying of a weapon. The judge sentences him to 90 days. This clip balances gravity with an almost comic human moment as the judge stumbles through her admonition. The slip of memory undercuts formality and adds authenticity, while the plea and sentence crystallize the legal outcome in a compact, consequential exchange. It's a concise portrait of how courtroom rituals and human error coexist.
You can go back with the
Thank you,
bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've said it so many times. But I can't stop in the middle and then restart. That's not good.
In this brief beat, the judge candidly admits losing her place while reading legal admonishments. It's a tiny, candid crack in court decorum that shows how routine repetition can fray concentration. For viewers, it's both disarming and relatable. Even in solemn settings, the human element slips through, making justice feel less like a machine and more like a conversation among people. That vulnerability gives context to the formal proceedings we've seen.
Lamone Yeoman, Mr. Rojas. Give me just a second. I'm going to print these out. They're both MTRPs, and it's just easier to find me. 19. Good morning. Are you Lamone Yeoman Jr.?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Let me get on. I should have another one coming also. Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building. And that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The Lamone Iman Jr. cases open with heavy allegations, aggravated assault, burglary, and probation violations. The court enumerates multiple serious counts, framing a high-stakes narrative, supply of synthetic drugs, failure to report, and alleged new offenses. The list reads like a dossier of escalating risk, setting an ominous tone for everything that follows. This clip frames the defendant as a figure caught in a pattern of alleged repeated misconduct.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
Not true.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025. And is that true or not true?
True.
Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025. And is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
No.
And did you plead true to those counts because they're actually true?
Here the defendant makes selective admissions, acknowledging some counts while denying others. Those contrasts create narrative friction. Each true tightens legal jeopardy, while each denial preserves a sliver of hope. This is courtroom theater at its core, the rhythm of accusation and reply that informs a judge's credibility calculus and shapes subsequent rulings and penalties. Watch the microdynamics. Admissions push consequence. Denials leave room for argument.
No.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So,
It is a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set, hold on. Anna, can you send me back 23-1556? I just sent it.
That may be the third degree paperwork. I think you may be right.
Yeah. Okay. I think, so 23-1556 is the burglary of a building,
Every state.
but y'all did TDC paperwork. And the other one, yeah. So those have to be right. So
We can read them.
I'm going to delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I think I got the numbers wrong. It didn't.
Okay.
I'm happy to redo them both.
Sorry.
That's my fault.
All right. I'm going to delete both of those. All right. Y'all just go have a seat in the jury box and we'll get that done.
Momentum halts when the judge and counsel discover paperwork errors. The procedural scramble, deleting entries, redoing forms, and pausing hearings exposes the administrative scaffolding behind each verdict. It's a revealing moment. The case's fate isn't only determined by facts and law, but also by clerical precision. A small mistake buys time and underscores human fallibility in legal process. This interlude shows how fragile courtroom progression can be.
I started, I was looking and I was like, wait a minute, that's because I thought it was a Kappa 2 on the TDC case. I'm like, what? Okay.
Yeah, I forgot there were different levels. Luke caught the mistake, I thought there were different levels.
Okay.
Do you want to plead Hendricks now, or do you want to do them when we do the other guy?
Go ahead and get that one done, and that way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Let's see. Mr. Kimler, you have Sheena Harmon.
Yes, sir. Judge, if I can, there's a lot of family members here on the side too.
Yeah,
With
which
Marvin,
one?
It's Christopher James.
Okay, I'll take care of it next.
Thank you.
Would y'all put that Christopher James sentencing up here for me to do next, please? Thank you. Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
This is
Harmon.
Harmon. This is
What did
Harmon.
I-
You call
This is
Harmon.
Harmon.
Oh, that's why I'm, never mind. Just testing everyone. Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
The court reorganizes, shuffles files, and cues the next set of defendants. This transitional clip functions like a breath between legal storms. Attorneys coordinate, family members move, and the docket's rhythm resumes. It's not empty filler. Watching logistics unfold gives viewers a clearer sense of how courtroom pacing, priorities, and momentum shape outcomes beyond the narrative of guilt or innocence. The clip reveals the practical choreography of justice.
Okay. And will your client waive the formal reading of the indictment?
So wait.
Miss, okay, we're going on all of the counts.
Whatever
Or at
makes it
least-
third.
Okay,
Whatever
got it.
gets us with the judges.
Okay, I got it.
I think we're gonna need all of them to get us to it.
Okay. Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic monitoring device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft June 28th of 2010, and then you were also convicted of the state jail felony offense of theft on June 24th of 2013, and on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There's none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Yes,
All right, good luck to you, ma'am. You can go back with the bailiff.
Sheena Harmon pleads guilty to tampering with an electronic monitoring device and faces a 6-year prison term. Prior convictions amplify stakes. The judge's admonitions about firearm ineligibility and immigration consequences add weight. This clip is heavy with consequence, an arc from admission to punishment that underscores cumulative legal peril and the harsh realities of repeat offenses. It's a stark example of how past records magnify present penalties.
I thought I printed, my printing thing is being, okay. Let's see, let me take care of Mr. Armstrong real quick, and then I'll take care of that sentencing. Colton Armstrong, Mr. Kimler.
We're pleading this as a 3rd degree.
Thank you.
He's gonna have to plead true to anything else. I guess there's some person. I mean, just here.
Good morning, are you Colton Armstrong?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
So wait. One, two.
Mr. Armstrong, in cause number 25, DCCR 0002, you're charged with the state jail felony offense of theft of property from February 21st of 2024. Your indictment alleges that you were previously convicted of the state jail felony offense of driving while intoxicated with a child passenger, October 31st of 2022, 2 cases on that same date of that same offense, making this a 3rd-degree felony punishment range. And how do you plead to that charge?
Guilty.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would not be a fine, but you would be ordered to pay restitution in the amount of $20,000. Is that your understanding?
Yes, ma'am.
Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Armstrong is not competent?
There's none, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to restate your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Ms. Malfino, what's the state's position with regard to bond?
Judge, may I just put one thing on the record first before that?
We're gonna come back for some.
Obviously, I was a little bit hesitant to make this offer based on those priors, and I just want Mr. Armstrong to be aware, I have relayed this through his attorney, that if he does not pay this restitution back, I won't be asking for the minimum that I offered him today, 15 months. I'm gonna ask for 10 years based on the opportunity that he's been given. I don't know that he doesn't have a hold in Hardin County. I'm not saying that disrespectfully, I just want him to be aware of what he's just gotten himself into. If
Sure.
the court follows the PSI. So I don't know if he has any holds.
I believe he does.
I'm a little hesitant to allow him on bond before you review the PSI, but I'll defer to what you think.
It sounds like based on that, and there is a hold from another
I
county.
can't say that they put a hold on him. I don't know. I know he has pending cases in Hardin County. I can't speak to whether there's a detainer on him from Hardin
And I've
County.
tried to reach out to Mr. Hopper over there and not get much.
Join the club.
Bruce.
Colton Armstrong's plea unfolds into a complex negotiation, a 10-year probated term, $20,000 restitution, and the shadow of prior DUI with child convictions. The prosecutor warns that non-payment could trigger far harsher penalties. This segment layers legal mercy with conditional risk, revealing how plea bargains trade leniency for strict, enforceable obligations, and how fragile those deals can be. It's a careful negotiation where compliance determines future freedom.
He does have a pregnant wife, Your Honor, this due fairly soon.
31 weeks, right?
31 weeks. Almost said 31 months.
Oh my gosh, wouldn't that
Feels
be?
like it.
It does.
I wouldn't know. I think the two, he has an unauthorized use of another vehicle and a theft of the same vehicle in Hardin County.
He does have 2 Hardin County holds.
So those would have to be cleared as well.
Yeah, and by the time, I'm afraid if I set a bond and then they get them over here, then we're not going to get the PSI. It's just going to prolong everything. And I think I'd rather go ahead. I'm not going to adjust the bond at this time. Let's get it taken care of. And then as soon as sentencing gets here, if everything goes well, you'll be released, at least from our custody. And then you can go take care of your Hardin County cases. All right, you can go back with the bailiff.
Thank you.
Thank you.
Thank you. Who's crying? I haven't even done anything to, I haven't even been that mean yet today. Well, I'm about to. I would probably be too. Mr. Lewis, Christopher James, Mr. Rojas, Mr. Nichols.
Christopher James.
Good morning. Are you Christopher James?
Yes, ma'am.
And Mr. James was previously in court, entered a plea of guilty to the first-degree felony offense of intoxication manslaughter with a vehicle. I've received the pre-sentence report and also a supplemental memorandum from probation that includes several letters from the victim's family members. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor, I just want to make the court aware, Mrs. Addison, the deceased's wife, would have been here today to do victim impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact at the end of sentencing.
Okay, thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. Mr. was the decedent, Mr. Addison, his family, as well as Mr. James and his family. it was a situation where, this was a combination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James and different substances over a period of time. The one thing I can say is that once Mr. James went through this situation with this accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways in going to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA.
The Christopher James sentencing segment is the emotional capstone, a first-degree intoxication manslaughter case, pre-sentence reports, and victim impact setup. Counsel frames the defendant's attempts at rehabilitation while the court readies for family testimony. This is where legal consequence meets human sorrow, the most affecting and solemn moment in the tape. Like the video? Please like the video and subscribe to the channel, and we'll see you in the next video.